New points on work permits for foreigners in Vietnam under Labor Code 2019 and Law on Investment 2020, Part 1. In fact, foreign investors have created a strong economic resource to develop in all aspects in Vietnam. The investment capital of foreign investors over the past years has created many values in economic growth, infrastructure development, improvement of social life, and creating employment resources. Hence, the law of Vietnam tends for facilitating to welcome foreign investors to come to Vietnam. Besides basic positive issues, there are still cases of foreigners taking advantage of Vietnam's investment policies to enter our country for other purposes, even though they are not qualified to work in Vietnam, as well as taking advantage of the provisions of the current law. They have stayed in Vietnam to live and work even though they are not the subjects allowed to work in Vietnam. Consequently, the consequences in social life, order, and national security are seriously arisen. There is a need for legal provisions to create the best conditions to attract the investment resources and control the activities of foreigners in Vietnam to ensure the security, order, and national defense of the country at the same time. Through this article, we would like to discuss some issues of the Labor Code 2019 and the Law on Investment 2020 that have been enacted with notable issues related to work permits, hereinafter referred to as WP, and notable regulations on foreign investors. Regulations on foreign investors and work permits are specified in the Labor Code 2012 and the Investment Law 2014. As prescribed in Clause 14, Article 3 of the Law on Investment 2014, foreign investor is an individual with foreign nationality, an organization established under the foreign law conducting business investment activities in Vietnam. According to the above-mentioned provisions, foreign investors include individuals and economic organizations. When investing in Vietnam, foreign investors can invest through 04 forms: investment in establishing economic organizations, investments in the form of capital contribution, share purchase, capital contribution to economic organizations, investment in the form of PPP contract, investment in the form of BCC contract. When investing in Vietnam, foreign investors should note that the conditional investment sectors are specified in Appendix 4 of the Investment Law 2014 and the sectors and services that foreign investors are not allowed to invest in Vietnam. Regulations are scattered in legal documents, decrees, and circulars such as lottery business, publisher establishment, industrial property representation services, industrial property assessment services. In order to making favorable conditions for the investment process, attracting more foreign investors, at Article 172 of the Labor Code 2012, there are some cases where foreign citizens working in Vietnam are exempted from work permits such as 1. Capital contributor or owner of a limited liability company. 2. Member of the board of directors of a joint stock company. According to the above-mentioned provisions, foreign investors investing in Vietnam through two forms, which are investment in the establishment of economic organizations and investment in the form of capital contribution, share purchase, capital contribution to the economic organizations, will be exempted from work permits. From the above-mentioned regulations, in fact, the following problems have occurred. Firstly, the fact that foreign investors investing in Vietnam in the form of establishing economic organizations and contributing capital, buying shares, and contributing capital to the economic organizations are not subject to the issuance of legal licenses is the regulation promoting the investment process in Vietnam to be faster. When foreigners entering Vietnam are required to apply for a work permit, they have to prepare a lot of papers to apply for a work permit specified in Article 10 of Decree No. 11/2016/NDCP detailing the implementation of a number of articles of the Labor Code regarding foreign workers working in Vietnam. Decree No. 11/2016/NDCP, such as 1. Proposal of issuing the work permit of the employer in accordance with the regulations of the Ministry of Labor, War Invalids and Social Affairs. 2. Health certificate. 3. Judicial record or documents certifying that the foreign worker is not a criminal or prosecuted for criminal liability issued by the foreign country. 4. Proof of identity as manager, executive director, expert or technical worker. 5. Certified copy of passport or passport substitute document or international travel document valid as prescribed by law. 6. Documents relating to the foreign worker. On the other hand, Vietnam only grants WP to subjects having professional qualifications and skills such as manager, executives, experts or technical workers. Thus, foreign workers working in Vietnam are highly qualified people. Meanwhile, the dossier submitted in case foreigners are not required for granting work permit only includes 1. A written request to confirm that the foreign worker is not required for granting a work permit. 2. A list of foreign workers with the following contents: full name, years old, sex, nationality, passport, work start date and end date, the job positions of the foreign worker. 3. Documents proving that the foreign worker is not required to be issued a work permit. The procedure for the confirmation is also simpler than the one for granting WP specified in Article 8 of the Decree No. 11/2016/NDCP, which takes 03 working days from the date of receiving a complete application. The Department of Labor, War Invalids and Social Affairs where the foreigner is expected to work shall send a written confirmation to the employer. In case of rejecting, they will reply in writing and state the reason.